number 020411, which entitled the claimant to be placed on salary below the one on which he retired, which is 161,364 naira 94 kobo. 2, a declaration of the Honorable Court that the claimant has been short paid from July 2013 to December 2014 by 2,138,832 naira 77 kobo. 3, a declaration from a renewed contract from January 2015 to November 2015 is entitled to remuneration of 7,584,152 naira 18 kobo for the period applying the appropriate PSR Rule 020411. 4, an order of this Honorable Court to the defendants to apply PSR 020411 on claimant's appointment, recomputed his emolument in full and pay the shortfall. 5, an order of this Honorable Court for the defendants to pay all the outstanding salaries of the claimant with immediate effect from January 2015 to November 2018, and any shortfall in salary from July 2013 to December 2014. 6, an order of this Honorable Court for the defendants to pay interest at 10% per annum on the outstanding salary or shortfall of each month from the date it first becomes due until the date it is paid. 7, an order of this Honorable Court for the defendant to pay interest at 10% per annum on the total outstanding salary or shortfall after judgment today it is paid. 8, an order of this Honorable Court restraining the defendant from forcefully ejecting the claimant from the staff quarter onto the final determination of the suit. 9, an order of this Honorable Court for the award of damages against the defendants in the sum of 5 million naira for emotional and psychological trauma, physical suffering because of emoluments on their due date. 10, an order of this Honorable Court directing the defendant to pay 1 million naira being the cost of litigation in this suit. And 11 is an omnibus prayer. Just a minute. It is the claimant's case that he worked and retired from the services of the first defendant on the 19th of June 2013 on grade level 14, step 10 on the salary of 161,304 naira employed on contract by the first defendant on the first day of July 2013 on a fixed salary of 100,000 naira that he, however, recently discovered that the first defendant failed to apply the public service rule in placing him on the contract appointment instead of placing him on salary grade level 13, being the grade level below the one he retired on. He averred that his contract was renewed on the 31st of October 2016 and was further renewed after a period of 1 year dated 8th of December 2017 and was informed via the letter dated 16th of November 2018, notifying him that the contract will not be renewed. He also stated that the payment of his salary from 2013 to December 2014, which is about 8 months, was irregular, as well as 2 months' salary were missing, and the details of the deductions was not stated, neither was his pay slip given to him by the defendant indicating the amount and analysis of deductions before the net paid into his bank account. He continued that the total amount paid should be 1.8 million naira, less 126,000 rent, which sums up to 1,674,000 and less any tax. Was not paid salary from January 2015 to November 2018, amounting to 4,700,000 naira, which is subject to tax for 47 months. He continued that he and other affected workers made a joint representation to the management demanding for payment due to them, but all to no avail. That he was allocated a residential quarter of 3-bedroom with a monthly rental payment of 7,000 naira, which was deducted from his salary. He averred further that he has been waiting for the payment of the money owed to him by the first defendant for him to vacate the quarters. But the first defendant wrote him a letter dated 4th of March 2019, asking him to vacate the said property, and was further given an oral warning to vacate the premises within 7 days or will be forced out. Defendants on. Defendants on the 15th of March 2021 filed a joint statement of defense where they averred that only employees of the first defendant who are active in service are regulated by the public service rules, whereas the claimant's employment was based on contract and purely negotiated, which he can accept or reject, and as such, the claimant contract is not subjected to the public service rules with the condition clearly stated on the offer of contract of employment. Defendant averred that the claimant agreed to the terms of the contract and fulfilled the conditions contained therein when he wrote an acceptance letter. According to that, the claimant is not entitled to the figure he's claiming, as the contract of appointment letter clearly stipulated a sum of 100,000 naira. They continued that claimant's salary was consistently paid into his account without any delay. Defendant further averred that the claimant's actual salary from July 2013 to October 2014 was 1,796,666 naira 66 kobo, 67 kobo gross pay, and 811,526 naira 43 kobo amount paid, including all deductions in form of taxes, rent, and utilities, which was clearly demonstrated from the third month were irregular, but not complete, as the claimant erroneously alleged that the claimant was paid the purported 2-month salary through several bill units in cash. They stated that it is the practice of the first defendant to forward details of deductions to the account of his employees, but only the net pay is forwarded to the bank. However, employees are at liberty to approach the finance department for the pay slip containing all deductions, breakthrough of salary. The claimant's contract was determined on the 31st of October 2018, amounting to 46 months against the assertion of the claimant, and the gross salary of the claimant is 4,600,000 naira against his allegations, hence not entitled to a gross salary, as several deductions must be made from the account, including taxes, cooperative rent, and utilities, amongst others. That notwithstanding the gross salary of the claimant, which is 4.6 million naira, the deduction in tax and cooperative for the entire period from January 2015 to 31st October 2018 is 2,804,995 naira only. The total deduction of rent and utilities, according to the defendants, is 402,500 naira, while the net payment accrued to the claimant is 2,002,033 naira 24 kobo. Defendant further averred that the contract between the claimant and the first defendant expired on the 31st of October 2018, and he was served a notice to vacate the premises which he is still occupying, noting it is a standard practice of the first defendant that at the expiration of an employee's engagement, such an employee must vacate the quarters immediately, and an F worker is not allowed to hold on to any sub quarters as much as the claimant did. Hence, the defendant's counterclaim against the claimant as follows. A, the sum of 245,000 naira as the cumulative rent and utilities consumed by the claimant from the 31st of October 2018 to 28th day of February 2021. B, deduction of 8,750 naira as monthly deduction from the claimant enjoyment of the quarters from the first day of March 2021 until the matter is determined. And C, an order of set-off of the sum of 245,000 from the claims of the claimant. In the course of trial, the claimant testified for himself as CW. He adopted his written statement on oath dated 30th of June 2021 and equally tendered documents admitted and marked as Exhibit F to S9. He was also cross-examined by counsel on behalf of the defendants. The defendants called two witnesses, one Matthew Pajafa Bohr, who testified for 8 as DW. He adopted his written statement on oath and also excuse me.
Easy. Sorry, my love. Sorry, my love.
Just a minute. I'll take that again. The claimant testified for himself as CW. He adopted his written statement on oath of 30th of June 2021 and the documents meted and marked as Exhibit S to S9. He was also cross-examined by counsel on behalf of the defendants, and he closed his case. The defendants called two witnesses, one Matthew Kwajafo Boy, who testified for it as DW. He equally adopted his written statement on oath, and DW2, one Matthew Aman Abdul Amos, testified for the defendants as well. DW2 tendered documents, admitted and marked as Exhibit N to M2. He was also cross-examined by the claimant counsel, and a document was tendered through him, which was admitted as Exhibit M3. On the 22nd of July 2021, counsel on behalf of the defendants filed his final written address. I have reduced the pertinent part of it into the body of this judgment. And claimant equally filed final written address. I've equally reduced the most germane part into the body of this judgment. I will now go straight into the decision of the court. I've carefully perused the processes filed in this case, the exhibit tendered by both parties, final written addresses of both parties, and the reply on point of law filed by counsel on behalf of the defendants. I'm of a firm view that these issues will best determine this case. They are: one, whether the employment is statutory to justify the application of a public service rule, and two, whether the claimant is entitled to the relief sought in this case. As a preliminary issue, I need to discuss the issue raised by counsel for the defendant on the admissibility or otherwise of Exhibit M3 in his final written address in this case. It is counsel's contention that Exhibit M3, though already admitted, should be expunged because it was neither pleaded nor front-loaded. He equally contended that the document runs afoul of the provision of Section 83, Subsection 3 of the Evidence Act, being a document made during the pendency of this case. Counsel to the claimant, on the other hand, in his address, argued that since the said document is relevant, it is nonetheless admissible. He equally argued that the maker of Exhibit M3 could not be regarded as an interested party to nullify the admissibility of it. In the case of Garba and others versus DG, Bureau of Land, Kwara State, and another citation is captured. The case of Magaji and Nigeria Army, citation is equally captured. The court held that the cardinal consideration in the admissibility of the document is relevancy. As such, once a document is relevant to the facts in issue and is legally admissible, it will be admitted. In the case of Garba and Muhammad and other citation is provided, the Court of Appeal held that the document is rendered admissible if it is pleaded or facts relating thereto has been pleaded. As such, a document need not be specifically pleaded to be admissible so long as facts which they seek to establish was expressly pleaded. Documents are not pleaded, but facts linking the documents to the facts in issue. See the case of Sani and Kogi State House of Assembly and others, citation is provided. The case of Amino and others versus Hassan and others, citation captured. And the case of Akon Jom and others versus Ekom and others, citation is equally provided. The defendants pleaded read paragraphs of their statement of defense that they made deductions from claimant salaries from 2013 to 2014 and specifically gave accounts of the deductions made, including that of cooperatives, which is ultimate cooperative society, as seen on the table in paragraph 14 of their statement of defense. As such, the facts covered by Exhibit M3 have been pleaded by the defendants. Therefore, Exhibit M3 is admissible in evidence. On the second leg of the objection, Section 83(3) of the Evidence Act is anchored on the doctrine of lis pendens, which forbids the admission of statements or documents made pending lied. Let it be known that mere fact that a document was prepared during the pendency or in anticipation of a case does not render them inadmissible under Section 83, Subsection 3 of the Evidence Act. This is particularly so as Exhibit M3 has not been rendered ab initio illegal and inadmissible. The law also requires that it must be shown that its maker has an interest in the outcome of the case to render it inadmissible. In the case of NBC PLC and Ubani, citation is provided. It has been held that the word quote and unquote interested in Section 91, Subsection 3, which is now Section 83, Subsection 3 of the Evidence Act, that it must be given a narrow rather than a broad meaning. See the case of Anye Ebosi versus RT Briscoe Nigeria Limited, citation is provided. The case of Akina Zayetobi, citation is equally provided. The most germane question to answer at this stage is whether the maker of Exhibit M3 is an interested person in this suit. In other words, does he have an interest in the outcome of the suit? There must be a likelihood of bias before a person can be said to be an interested person. So the case of Adedoro and Ogoluwaki, Thought Trading Company Limited, citation is provided. In the case of Abdullahi versus Meitida and others, citation is captured. It was held that, I quote, in order to ascertain or determine whether the maker of a document sought to be tendered is a person interested in the litigation under Section 91, Subsection 3, now Section 83, Subsection 3 of the Evidence Act, the circumstances surrounding the making of a document and whether the maker can be said to have an interest of a personal nature must be examined and ascertained. A person who is not personally interested in the result of litigation cannot be described as one interested in the proceedings. A person under official benefit from the outcome of the litigation cannot also be said to be a person interested under Section 91, now Subsection 83(3) of the Evidence Act, unquote. It is clear that the makers of Exhibit M3, in view of the definition of quote and unquote maker of a statement contemplated by Section 83, Subsection 3 of the Evidence Act, excuse me, are the president and chairman of the ultimate cooperative, that is cooperative society, which the defendant proceeded. They paid certain deductions made from the salaries of the claimant too. There's no doubt that Section 83(3) of the Evidence Act was enacted to render any statement made in a document inadmissible where such is prepared by an interested party for the purpose of defeating the cause of justice. This is because the maker of a document who knows about the pendency of a dispute or anticipate that a dispute might arise may be tempted to depart from the truth by reason of the interest he has in the matter. To determine whether or not the maker of a document is an interested person as contemplated by that section, the court will consider the nature of the duty performed so as to know if he had a temptation to depart from the truth or whether he was swayed by personal interest or was detached judicially, impartially, and independently. In the case of UBA PLC and PEB 04 Nigeria Limited, citation is captured. The makers of Exhibit M3, to my mind, do not have any personal interest in the suit. It is clear from the face of the exhibit as stated that the claimant is no longer indebted to the cooperative, so they do not really have any interest to serve. They merely made the statement in respect of the debt portfolio of the claimant, if any, to the said cooperative. In essence, the document was produced in respect of the standing of the claimant with the cooperative society. I do not think the makers of the document have any personal purpose to serve in making the document, as I've said, supra. They merely stated what they know in respect of the claimant in the cooperative. As such, I find it very hard to hold them as interested persons. They merely acted in their official capacity as the officials of the cooperative society. I therefore find that Exhibit M3 is admissible and stands admitted while the probative value to attach to it is another, being that the document was not tendered through its maker. So the case of Flash Peak Odds Limited versus S. Akatubua, citation is provided. The case of Wager 4 and Access Bank, citation is also provided. It was tendered through a person who was not one of the makers, who even denied knowledge of the exhibit, and no explanation was made for the failure to call the makers of the said document as a witness. Thus, this court will attach minimal value to Exhibit M3. Now to issue 1. It is not an issue in this case that the claimant once worked in the service of a first defendant and retired, as seen in Exhibits S1 and S2 respectively. It is equally not in dispute that the claimant was subsequently taken back into the fold of the defendant on a temporary basis on contract employment. However, the contention hearing between the parties centers on the applicability of the Public Service Rules 2008 to the employment relationship between the parties. It is tried that the PSR vests public servants with a legal status higher than that of an ordinary master servant. In the case of Bashir Alade Shitabe versus the Federal Public Service Commission, citation is captured. The Apex Court, per Idigbe JSC, now of blessed memory, expounded on the frontiers on employment with statutory flavors as and I quote, the civil service rules of the Federal Public Service govern condition of service of federal public servants, and they are made pursuant to the powers conferred on the respondent by virtue of the constitutional provisions in the 1963 Constitution. And the rules relevant to these proceedings were made in 1974 pursuant to the provision of Section 161 of the 1963 Constitution at number 20 of the 1963. These rules, therefore, in my view, have constitutional force, and they invest the public servant over whom they prevail a legal status, a status which makes his relationship with the respondent and government, although one of master and servant, certainly beyond the ordinary master and servant relationship. Under these rules, that is the 1974 rules, which, as I already pointed out, have statutory force and therefore ought to be judicially noticed, unquote. See also the cases of Controller General of Custom and Guzau, citation is provided. The case of Imalaume and Wae, citation is captured. Okocha versus Civil Service Commission of Edo State, citation is equally provided. The case of Okeme and Civil Service Commission in Edo State, citation is provided. In essence, by virtue of the Public Service Rules, which is a subsidiary legislation, though has constitutional force, public servants are vested with the status of statutory employees whose employment is clothed with statutory flavor. It is therefore not out of place to say that only public servants, strictly so-called, have their employment clothed with statutory flavor by virtue of the Public Service Rules. It is equally not out of place for one to say that the Public Service Rules apply to the public service of the Federation and public servants. That said, can the contract staff, like the claimant, be regarded as a public servant, having already retired from the service of the first defendant? It should be noted that the defendant herein is a limited liability company, even though parties are added that the federal government owns it. In the case of Awala and Nigeria Telecom, citation is captured. The Apex Court held that a limited liability company incorporated under the Companies and Allied Matters Act or any other law under which such company is registered, whether owned by government or by private persons, is governed by its own rules and condition of service and not by the civil service rules. The court went further in that case to hold that although the respondent was wholly owned by the federal government, it is not part of the civil service. It was a limited liability company with powers to sue and be sued. Any attempt to say that the employees are civil servants is an attempt to obliterate the corporate identity of the company. See also the case of Sule and Nigeria Cotton Board, citation is provided. The Supreme Court, per ONU JSC, as it then was, in the case of Okomu Oil Palm Limited, versus Seyenhe, citation is captured, had this to say, and I quote him, besides, having a controlling numbers of shares in a company is not synonymous with its ownership once it is incorporated as an entity of its own and having its own separate legal existence. Whatever impression was therefore given in this case that the Federal Civil Service Commission sat in the background and maintained a direct or remote control over the activities of the appellant by applying thereto its rules, a corporate entity with its own legal existence must be rejected as a wrong and ill-conceived legal proposition, unquote. It's also the case of Aso Motel Kaduna Limited and DMO citation is provided. In the same vein, the Apex Court in the case of Awala and Nigeria Telecom Supra, paragraphs G to E, page 38, had the opportunity to comment, the Supreme Court had the opportunity to comment on the scope of the public officer in relation to public service of the Federation under Section 277, Subsection 1, and the fifth schedule of the 79 Constitution, which is the same as Section 318, Subsection 1 of the fifth schedule of the 1999 Constitution as altered. And I quote them. Under Section 2771 of the 79 Constitution, public service of the Federation was defined as the service of the Federation in any capacity in respect of the government of the Federation and included service as staff of any company or enterprise in which the government of the Federation or its agency owns controlling share or interest. However, that did not mean an employee of government-owned companies was therefore a public officer. The definition was reflective of, and particularly consistent with the provision in the fifth schedule to the Constitution, which dealt with the Code of Conduct for Public Officers. The interpretation paragraph 21 of the schedule defined public officer to mean a person holding any of the offices specified in Part 2 of the schedule. That part provided for public officers for the purposes of the Code of Conduct and maintained as a long list, which included staff of statutory corporations and of companies in which the federal or state government has controlling interest. In this case, the mere fact that the appellant was employed by the respondent, a company wholly owned by the federal government of Nigeria, did not by itself mean he was a public officer, unquote. It is deducible from all the above captured decisions that employment in the first defendant's company, which is a limited liability company, whether on pensionable employment or temporary basis, does not translate the employment to be one in the civil service or the public service of the Federation. This is because the company is not part of the public service of the Federation. It is equally evident in Exhibit S1, Ida's claimant's letter of offer of employment by the defunct Nigeria Steel Development Authority, now Ajaokuta Steel Company Limited, that is the first defendant, at its paragraph 1C thereof, that he, that is the claimant, will be subject to, I quote, the authority's condition of service and such other regulations and instructions as may be adopted by the authority from time to time, unquote. This is a clear indication that the first defendant's employees were never public servants or had their employment regulated by the public service rules as asserted by the claimant. As such, the employees of the first defendant, whether in pensionable or temporary employment, cannot be regarded as public servants. Consequent upon which I find that the public service rules do not govern the employment in the first defendant, including that of the claimant. Issue 1 is thus resolved against the claimant. In view of this, reliefs 1, 3, and 4 in the amended statement of facts as it relates to the PSR fail. In respect of issue 2, having held that employment in the first defendant, including that of the claimant, is not one in the public service, it therefore means that the employment of the claimant is not one clothed with statutory flavor, but one bound by the common law rules of master-servant, where parties are governed by the terms of contract entered into. Indeed, the law is on a firm terra that the relationship between a master and his servant or employer and his employees is a contractual one, and it is governed and regulated by the terms and conditions of the contract between them. See the case of Ilo Lobo and NPDC Limited citation is captured. The notorious case of Longe and First Bank of Nigeria PLC citation is provided. Case of Ekwola and CBN citation is captured. The law is also settled that the rights, obligations, and liabilities of the parties to such a contract are to be determined on the basis of the terms and conditions which they have freely and voluntarily agreed to govern and regulate the relationship between them. See the case of Shina Security Company Limited and Afropac Nigeria Limited, citation is provided. Case of Calabar Cement Company Limited and Daniel, citation captured. The case of Cato and CBN, citation is also provided. In the same vein, the law does not permit the court to alter by subtraction or addition or rewrite the terms and conditions of a contract entered into by the parties on the pretext of exercising a judicial discretion that completely ignores the sanctity of their agreement. So the case of RG and CBDA, citation provided. The case of Oak Pensions Limited and others versus Ola Inca, citation is equally captured. This is because the common law recognizes and respects the sanctity of contracts, and this is represented in Lacti Maxim, Pacta Sunt Servanda, is a sacred doctrine for the preservation of contract, which is entitled to the greatest respect by parties and the court. Hence, where parties have reduced the terms and conditions of service into an agreement, the conditions must be observed. So the case of Maye and UBN, citation is provided. In effect, what governs the contract of employment relationship between the parties herein is the letters of contract of appointment and renewals given to the claimant herein. Thus, the terms of the contract and renewal of same are contained in the bundle of documents in Exhibit S4. For ease of reference and better appreciation of same are hereunder captured those. Dated 1st July 2013, addressed to the claimant Daily Saliu, titled Offer of Contract Appointment. Please refer to your application for contract employment with the company. I'm pleased to inform you that you have been offered contract appointment as chief supervisor in the company on consolidated salary of 100,000 naira per month with effect from the date you assume duty. 2. However, this offer is subject to the following conditions. 1. That you complete a contract agreement form on assumption of duty. 2. That you submit on assumption of duties a recent and satisfactory medical report from the company's medical center. And 3. That you produce satisfactory discharge certificate from your former employer. Yours faithfully, signed by Ajakuta Steel Company, one Ada Osefi, Mrs. Unquote. This contract was renewed via the letter dated 31st of October 2016, and it was also addressed to claimant, title renewal of contract appointment. Quote, this has reference to the appointment letter ASCL/CF.17186 dated 1st July 2013. Management has directed that your contract appointment be renewed for another 1 year from 1st November 2016 to 1st November 2017. All other terms of your contract appointment remain unchanged. Thank you. Yours faithfully, Ajakuta, signed by Ahmed A.S. Unquote. This contract was equally renewed with a letter dated 8th of December 2017, addressed to the claimant, title renotification of expiration of contract of appointment. I quote, this is in reference to a letter ASCL/CF.17186/2012 dated 14th November 2017 on the above subject matter. Management has directed that your contract of appointment be renewed for another 1 year with effect from 2nd November 2017 to 1st November 2018. All other terms of your contract appointment remain unchanged. In view of the above, you are requested to report to head RM for further assignment. By a copy of this letter, Finance is being advised to implement accordingly. Thank you. Yours faithfully, signed by the same Ahmed A.S. Unquote. It is right that document, legally speaking, speaks for itself. See the following cases: Oyeleke and Oyedino, citation captured. The case of Ezi and Uche versus Idigbe, citation is provided. The case of Ezi and Abga, citation is captured. The case of Yadiz Nigeria Limited versus GNIC Limited, citation is also provided. The contents of letters reproduced above are clear and do not require any special aid to understand or comprehend it. It is clear from the above letters that the claimant is to be paid the sum of 100,000 naira salary during the subsistence of the contract, and which term was incorporated into the said letter dated 1st July 2013, and subsequent renewal letters dated 31st of October 2016 and 8th of December 2017, respectively. It is the claimant's claim that he was short paid and the payment of his salary has been irregular and incomplete from July 2013 to December 2014 by the sum of 2,138,832 naira 77 kobo. He gave notice to the defendants to produce details of payment of his salary when paid and analysis of the deductions from July 2013 to December 2014. Defendants in response gave the account of the true payments made into claimant's account and contended that though the payments were made were irregular, but they were not incomplete as alleged by claimant. They equally contended that deductions for tax, cooperative, rent, and utilities consumed by the claimant were made from his gross salary before the net pay. In support of their assertion, they tendered Exhibit M to M2. It is the law in the world of works as espoused by ILO Protection of Wages Convention of 1949, number 95, which Nigeria ratified on the 17th of October 1960 in its Article 8.1. This provision has been incorporated and domesticated in Section 5 of the Labor Act to the effect that there shall be no deductions or reductions of wages and salaries of an employee without his prior consent. In actual fact, the law frowns at the practice of reduction of wages except with the consent of the employee or the employee's union. By virtue of Section 82 of the Personal Income Tax Act, Laws of the Federation of Nigeria 2004 as amended by the Personal Income Tax Amendment Act 2011, an employer is required under the Act to make deductions from the emoluments or amounts on account of emoluments paid by the employer to the employee, and he shall account to the relevant tax authorities in the manner prescribed by the tax authority for the deductions so made. See the case of NDDC versus River State Bureau of Internal Revenue citation is captured. These taxes so deducted are usually referred to as withholding taxes, which are to be remitted by the employer in the employee's name to the tax authority. This was well captured by the Black's Law Dictionary 8th edition at page 1632, defining withholding tax as follows, I quote, deductions from salaries or wages, usually for income taxes or social security, and contributions to be remitted by the employer in the employee's name to the taxing authority, unquote. See also the case of NDDC and Rivers Bureau of Internal Revenue, Supra. Therefore, I find that it is within the lawful province of the employer, like the first defendant in this case, to make tax deductions from the salaries of the claimant. It is noteworthy that the claimant did not file a reply to counter the specific facts averred and documents pleaded in the defendant's joint statement of defense on the issue of deductions or payment of a 2-month salary or any other new issues raised in the joint statement of defense of the defendant. This issue was equally raised in the written address filed on behalf of the defendants and his argument of issue 2 raised therein. In the case of a Gesimba versus Onozurike citation is provided, the Apex Court held that when a court is faced with the contention that the failure of the plaintiff to file a reply should affect the result of the case, the proper approach is first to inquire whether a reply was essential, and secondly, if it was, whether evidence of the fact which should have been pleaded in the reply had been adduced and admitted. The law is that where a statement of defense raises new facts and asserts specific issues which were not covered by the averments contained in statement of claim or fact, it is incumbent on such a claimant to file a reply to respond to the new facts, and failure to do so means that he will be deemed to have admitted the new facts and cannot lead evidence in rebuttal of the facts at the trial. So the following cases: Odera Investment Company Limited versus Ecobank Nigeria PLC, citation is provided. The case of Usman and First Bank and other citation is provided. The case of Woha versus Post Limited, citation is captured. Thus, it is in my respectful view that reply is essential in this case, since the pleading of the defendants raised first issues of deductions for cooperative, tax, and rent from the salaries of the claimant, and the issue of the payment of the missing 2-month salary by cash. Claimant had a duty to file a reply to the joint statement of defense of the defendants on this first issue. Again, claimant hearing had not adduced any cogent evidence of any fact which should have been pleaded in the reply if filed. Excuse me. Hence, the effect of a failure of the claimant is an admission of facts pleaded by the defendants in their joint statement of defense on the issue of deductions for cooperative, tax, and rent, and that is only entitled to the sums paid into his account after those deductions. The law is of common that facts admitted need no further proof. See the case of Adebayo and Benue State University, citation is captured. Case of Olatuji and Unity Bank PLC, citation is equally captured. This equally claimant's claim, indeed, is amended statement of fact that 2-month salaries are missing from the extract in the bank statement. The defendants responded that the purported 2-month salary which were missing were paid in cash. They pleaded and relied on a payment voucher signed by the claimant indicating the transaction. In support of this, the defendants then tendered Exhibit M1. As stated earlier, the claimant failed to file a reply to the joint statement of defense of the defendants, which effect is that the claimant has admitted the facts pleaded in the said statement of defense and confirmed that the sums allegedly paid via Exhibit M1 was received by him. Stated in another way, claimant admitted he was the one that signed the said payment vouchers after receipt of the said money. I perused the said Exhibit M1, which is the payment voucher signed by the claimant after receipt of cash payments. I find in it that the voucher was approved, that the voucher approved the payment of a sum of 150,000 as arrears of salary, but the claimant only signed for the receipt of 90,000 as rightly submitted by Leonard Claimant Counsel in the final written address as against the sum of 110,000 on the front page of Exhibit M1, or the sum of 150,000 naira in respect of which the voucher was prepared. Let me at this stage comment on the manner in which claimant's salary was paid via Exhibit M1. An employee, whether on contract or full-time, who has worked, has earned his salary or wages and cannot be denied access to them or to that under any guise, ploy, or excuse. I find it inhumane and tantamount to unfair labor practice for the defendants to issue a voucher for the payment of salaries of a claimant in the sum of 150,000 naira and then start paying the money in bits and piecemeal in the manner they did in Exhibit M1. The law by Section 15 of Labor Act provides that wages or salaries shall become due and payable at the end of each period for which the contract is expressed to subsist, disease, daily, weekly, or at such other period as may be agreed upon, provided that where the period is more than 1 month, the wages or salary shall become due and payable at intervals not exceeding 1 month. See the case of Mr. Sule O. Usman and Union Bank of Nigeria PLC is an unreported suit number NICM/LA/56/2012, judgment of which was delivered on 21st of May 2014. It was held that employer's action of non-payment of salary of a worker as and when due was contrary to Nigeria international obligation under the ILO Convention and the Labor Act. By virtue of Section 254C, Subsection 1, paragraphs F, G, and H, and Subsection 2 of the 1999 Constitution as altered, this court is empowered to apply international best practices in labor, employment, and industrial relations, and the application or interpretation of international labor standards. Thus, any act of an employer contrary to the provision of ILO Convention due to international labor standards is to be held to be an unfair labor practice. It thus flows from the provisions of ILO Convention, Labor Act, as well as the case law authorities cited supra, that the first defendant's action of withholding and payment of claimant's earned salary in bits and piecemeal has without peradventure subjected the claimant to inhumane treatment. More so, where it is clear from Exhibit M1 that the full sum was not even paid. This kind of practice by the defendants should not be encouraged, as it amounts to an unfair labor practice as held earlier in this judgment. A laborer, the saying goes, and as it is tried, should not be denied access to his wages under any guise. The acts of the defendant as seen on Exhibit M1 is highly condemnable and inhumane treatment of the claimant. This should not be accepted in our labor relations. It is the right of the claimant to be paid his salary as and when due, as I reasoned supra. This right is inalienable and is human right. Honorable Justice Andrew K.C. Nyirenda, Judge, President, District Registry, High Court, Lilongwe, sees labor rights as human rights on the premise of fair labor practices, and then descend to other attributes. This is captured from his book titled, quote and unquote, Labor Rights as Human Rights. In Andrew Nyirenda and Rachel Zibelu Banda, ED, Protection and Promotion of Labor Rights, Industrial Relations Court, Series Malawi, at page 19. The Ilo Concept, an agenda on decent work, is not just about decency of work, but includes salary and payment of same as and when due, not in piecemeal or withholding same for months or years as done by the defendants herein. Hence, the law is strikes that a laborer is entitled to his wages not as at when able or desired by the employer, but must be paid at the end of every month as agreed by the claimant and the first defendant in his contract. The treatment meted out to the claimant by the defendant is demeaning against claimant's human dignity and does offense the right of the claimant under Section 34 of the 1999 Constitution as altered. This action, no doubt, will affect his dignity as a father, husband, and in his social life. The consequence of this is to be decided hereafter in this judgment, I so hold. Claimant equally pleaded that from January 2015 to November 2018, the defendant has not paid salaries which represent 47 months amounting to 4.7 million naira subject to tax. The defendants in response stated at paragraphs 19 to 22 of their joint statement of defense that contrary to claimant's allegation that his contract was determined on the 31st of October 2018 to make up for the 6 months and his gross salary will be 4.6 million naira less deductible in tax, rent, and cooperative, after which the net pay accrued to him should be 2,002,000 naira, 33 naira, 24 kobo. Excuse me. It is worthy of note that the defendants did not answer specifically on the issue of non-payment of the said salaries. They only pleaded how much accrued to the claimant without stating whether the sum has been paid or not. As I've stated earlier, claimant did not file a reply to the joint statement of defense of the defendants. However, this was conceded by DW2 when he answered under cross-examination on the 1st of July 2021 that the defendants have an outstanding salary they have not paid the claimant, and which is from January 2015 to October 2018. I am mindful of the fact that this action is declaratory in nature, and declaratory actions are the exceptions to the general rule of admission as provided in sections 20 and 21 of the Evidence Act. So the case of Al-Hassan and another versus Ishaku, citation captured. The case of Achi and another versus Chabo and others, citation is captured. The case of Oyetola and Adeleke and others, citation captured. The case of Okonkwo and Okonkwo, citation captured. The case of Omishori and Aregbeshola, citation is captured. The claimant, notwithstanding the admission of the defendant, supported his claim with Exhibit S10, which is the statement of account that shows that the claimant did not receive any salary from the defendants between those periods, that is, January 2015 to November 2018. I peruse the said Exhibit S10, and it is clear on the face of the said exhibit that the defendant did not pay a dime, or if I may use it in a Nigerian parlance, a kobo, to the account of the claimant between the periods in dispute. In my view, the claimant has successfully shown he was not paid salaries from January 2015 to November 2018. Parties are in contradistinction regarding when the claimant's contract was actually determined in order to determine whether the claimant was being owed 46 months or 47 months salary. A peruse Exhibit S4, particularly letter dated 8th of December 2017, And I find that the claimant's contract was renewed for another 1 year, effective from 2nd of November 2017 to 1st of November 2018. However, the defendants on their part still allow the claimant to work beyond the agreed date of 1st November 2018. The right of the defendant to terminate the employment by reason of exclusion of time, which was known to the defendants, did not entitle them to treat the contract of employment as having been determined on the 1st of November 2018. According to the claimant at paragraph 17 of his amended statement of facts, the letter of notification of expiration of his contract was not delivered to him until the 23rd of November at his duty post. It is also evidently clear on the letter that the head operations signed it on the 22nd of November 2018. This corroborates claimant's position in that the letter could not have been served on him before the signature of the head of operations. The defendants, in response to that, read paragraph 11 of their joint statement of defense, did not specifically traverse the averment of claimant that the said letter was served on him on 23rd of November 2018. It is right that an insufficient traverse amount to an admission. I therefore find that the defendants, by necessary and reasonable inference, admitted that the said letter was delivered to the claimant on the 23rd of November 2018. The court in the case of Okoha and another versus Osilama citation captured held inter alia while relying on the English case of Gizda versus CYE versus Barat citation captured that the correct view of the law is that an employment contract is brought to an end by a termination or dismissal letter sent by or on behalf of the employer to the employee at his or her address and delivered to that address, and that it comes to an end on the date of such delivery, regardless of whether or not the employee has there at that time or later on that day or did not see the letter. Sorry, or regardless of whether or not the employee was there at that time or later on that day or did not see the letter. It is therefore right to say that the effective date of termination of a claimant's contract is the date on which the letter was delivered to the claimant and not the date on which the letter was written. I have found that the defendant admitted by necessary implication the delivery of the letter to the claimant on the 23rd of November 2018. The claimant is therefore entitled to recover his salary up to the 23rd of November 2018, when he received the letter of termination of his contract. In view of the foregoing, I find that claimant's relief 5 proceeds only to the extent that the claimant is entitled to be paid his salaries from January 2015 to November 2018. I so find and hold. Claimant's relief 6 is of the nature of a prejudgment interest. The law is on the fair matera that prejudgment interest is one which is claimed by a claimant on the principal sum in a judgment at the prejudgment interest rate from the day the cause of action accrued to the judgment date. So the case of Fuani, Nigeria Limited versus Vidoko, citation is provided. It is equally trite that prejudgment interest is only to be awarded where the facts that support its award are pleaded and evidence led to support. So the case of Skimit Motors Limited versus UBA PLC, citation provided. The case of MPA versus Aminu Ibrahim and co, citation captured. It must equally be shown that parties have agreed on payment of interest in order to award an interest of this sort. See the case of AfriBank versus Akara, citation captured. The case of Idigbe Engineering Company Limited versus iHomo and another citation is equally provided. In the case of Julius Berger Nigeria Limited PLC versus PLCB Limited, citation captured, the Apex Court held that in addition to the fact that prejudgment interest must be pleaded and evidence led in support, the prevailing bank rate of interest and the date of commencement of calculation must be proved clearly by evidence. The claimant herein did not plead the fact that parties herein have agreed on payment of interest at the time they entered into the contractual arrangements between them. He equally did not lead any evidence in support of prejudgment interest or the prevailing bank rate or the date of commencement of SIP. In view of the foregoing, I find that claimant's relief 6 fails in its entirety. In respect of the 7th relief, it is right that where the rules of the court empowers the court to grant post-judgment interest, same may be granted, and it need not be pleaded or proved. A court of law is usually empowered by its rules to award post-judgment interest. So the case of AIB Limited versus IDS Limited citation is captured. The case of Federal Ministry of Health and DASCOM Nigeria Limited citation is also captured. The power of the court to grant same is discretionary, and the court is not under any compulsion to award same simply because it was claimed. In the case of Bolanle and Access Bank citation provided, the Court of Appeal held that the power of the court to grant post-judgment interest is statutory as it derives its root from the rules of court. And the NIC, that is this court, as a trial court in that case, derives such power from the National Industrial Court Rules 2017. This court is empowered by the provision of Rule 7 of the rules of the court to grant post-judgment interest at a rate not less than 10% per annum. In view of the fact that the defendants, even after the termination of employment of the claimant, until this moment, has failed to pay the claimant his earned salary from January 2015 to November 2018, which is most inhumane, as I've held supra, award post-judgment interest at the rate of 10% on the outstanding salary of the claimant. Relief 7 therefore succeeds. In the case of AP Limited and the Withholding citation is provided, the Apex Court per Caribbean White GSC of blessed memory held us, and I quote, "It is now well settled by decided cases of this court that for the purpose of the rent control and recovery of premises, the law recognizes only two classes of tenants. These are the contractual tenancies and the statutory tenancies," unquote. Employees who reside in the residential premises of employers fall within the category of contractual tenants, whose tenancy runs with the contract of employment. In the case of Sule versus Nigeria Cotton Board, citation captured, the Supreme Court held that once the appellant in that case, who was an employee of the respondent, held over the premises after he was retired by the respondent, he became a statutory tenant under Section 41, Subsection 1 of the Rent Control and Recovery of Premises Law number 9 of 1976. In essence, once the contract of employment of the claimant has been terminated, read as Exhibit 4, and he refused to vacate the apartment, he became a statutory tenant who cannot be forcefully ejected except on the order of the court of competent jurisdiction. Let me state that our court frown at the action of a party who adopts extrajudicial methods in doing things. The defendants herein will have committed an unlawful act if they had forcefully ejected the claimant from the quarters. However, there is no evidence before this court that defendants attempted to use force to eject the claimant. Be that as it may, the claimant, being a statutory tenant, cannot be forcefully ejected. It can only be ejected by an order of competent court, even after the determination of this suit. I so find and hold. Regarding the night relief, claimant is seeking for general damages. The terms of contract between the parties, as seen on Exhibit S4, is that the claimant shall be paid the sum of 100,000 naira as monthly salary. The defendants, by their failure to pay the claimant the salary between January 2015 to November 2018, amounts to a breach of the contract between parties. The law is tried that where a breach of contract has been established, nominal general damages will follow without need to specifically plead or prove the damages. So the case of SPDC Limited versus Nwabwesi citation is captured, and the case of Felix George and Company Limited citation is provided. It is well settled that once it has been found by a court that a party is liable for breach of contract, as in the instant case, award of general damages will follow, and such damages need not be specifically pleaded as they are not in the nature of special damages. The defendants, even after the termination of the contractual employment, still failed to pay the claimant his salaries, which were due to him. The Ilo Convention number 95 in Article 12, sub 1 and 2 provides that wages shall be paid regularly, and upon termination of contract of employment, final settlement of all wages due shall be effected in accordance with national laws or regulations or collective agreement or arbitration award, or in the absence of any applicable law, regulation, agreement of award, or award within reasonable period of time, having regard to the terms of contract. Section 15 of the Labor Act provides that wages shall become due and payable at the end of each period for which the contract is expressed to subsist as held supra. The period agreed upon by parties is monthly, and the defendant failed to honor this during and after termination of claimant's employment. This act of the defendants amounted to a breach of contract and is also against international labor standards as held herein before in this judgment, and its attendant consequences as capture supra at paragraph 34 of this judgment. For the inhumane and undignified treatment of the claimant, Ogakuje CA, in its decision in Sahara Energy Resources versus Oyebola, citation captured, reasoned that the ILO Convention, the recommendations of its Committee of Experts, application of international labor standards, which has a range of instruments and decisions of varying degrees that include declarations and resolution of ILO conference, customs, protocols, and treaties, a point of universal reference in relation to international best practices, and it's ascertainable. It is in consequence that I invoke the provision of Section 19D of the National Industrial Court Act 2006. This provision empowers me to award damages or compensation in deserving circumstances as in this instance. It is in that regard that I award the sum of 500,000 against the defendants as general damages in favor of the claimant. I so award. Claimant in Relief 10 is asking for the cost of action. The law is settled that costs, including costs of litigation, is at the discretion of the court once empowered by its rules. The rules of this court, particularly Order 55, empowers this court to grant costs of action at its own discretion. The discretionary power of the court is to be exercised judicially and judiciously. The claimant in the instant suit has successfully proven that the defendant refused to pay him his lawful entitlement from January 2015 to November 2018, while he failed in some parts of his case. In exercise of the discretionary power of this court to award costs, I award the sum of 100,000 naira only in favor of the claimant as cause of action in this suit. Now, in respect of a set-off claimed by the defendants, it is well settled in law that one of the methods of answering to an allegation of indebtedness is by way of a set-off. So the case of Airvia Limited versus Oriental Airlines Limited citation is provided. A defendant will successfully raise a set-off where he, in his statement of defense, states specifically that he does so by way of set-off and will proceed therein to give particulars. So the case of Benin Rubber Producers Limited and Ojo, citation provided. It is right that the defense of set-off should plead the facts giving rise to the debt or claim sought to be set off as fully as if they were contained in the statement of claim or statement of facts herein, and it should expressly state that the defendant will seek to set off such debt or claim in extinction or diminution of the claimant's claim. See the case of Unity Bank PLC and Oluwafemi, citation is provided. The defendants herein gave particulars of their set-off against the claimant and thereafter claimed certain sums against the claimant. Let it be known that the effect of a set-off, where successful, is to reduce the claimant's claim by the cross-claim. A set-off cannot result in judgment for the defendant or the difference between the set-off and the claim, where the former overtops the latter. So the case of Ascot Flow Line Limited versus Izu, citation is provided. Although the claimant herein, as stated earlier in this judgment, failed to file a reply to the new issues raised on the pleadings of the defendant, including the set-off which I've held to be an admission, I'm of a firm view that notwithstanding the implied admission of the claimant, the defendant ought to give sufficient particulars of the right to set off, lead credible evidence in support of their set-off in order to prove their entitlement or right to the set-off in view of the absence of a positive admission by the claimant. The defendants herein did not lead any evidence in proof of the sum of 8,750 naira claim as monthly rent and utilities consumption for the use and enjoyment of the third quarters. There's nothing to show that the parties agreed to that sum as monthly rent and utilities. There's equally nothing to show what amount cumulative rent to show what amount the cumulative rent and utilities consumed by the claimant in the sum of 245,000 naira. I am of the opinion that the defendants ought to plead with distinct particularity what amounted to utilities and how much specifically was rent and how much specifically was allotted to the utilities to amount to the sum of 8,750 naira. A set-off is a monetary claim by way of a cross-claim or counter-claim, which has the effect of reducing the claim of the claimant. In my view, the defendant's failure to give distinct particulars as stated above has entitled them to their claim for set-off. Consequently, the defendant's claim on the set-off fails in its entirety. I so hold. In sum, it is apparent from all the above that the claimant's claim succeeds in the most part and the defendant's set-off fails. I therefore make these declarations and orders. 1, claimant's employment is not regulated by PSR. 2, claimant is entitled to salaries from January 2015 to November 2018 in the sum of 4.7 million naira, less taxes. 3, the defendants are to pay claimant the sum of 500,000 as general damages. 4, defendant set-off fails. 5, cost is assessed at 100,000 naira. And 6, this judgment is to be complied with and all sums awarded to be paid within 30 days of this judgment, failing which it is to attract 10% interest per annum. Judgment accordingly entered.
Scott, please.
My Lord, we are most grateful for the erudite judgment. We are highly thank you.
Parties will get copies of this via the Lokoja office.
Okay, we are grateful, man.
Very well, I rise.
I see as my phone works.
It's supposed to now. I think this even woman be said continue to walk, you tire. No, it's your the thing favor you. It's 50-50.
So they cannot even force him out of the house until they seek for court order. Then they didn't favor the lawyer. Because lawyer is claiming 2.5 million. As the litigation is because she awarded 100,000.
You manage it.
Then they have to pay his salary from 2015 to 2018.
3 years.
For damages, 500,000.
It's okay. Somebody 3 years.
100,000.
But from it, you pay the lawyer fee from that money. You pay him, the lawyer, his lawyer. Yes. I don't know whether the other side they may appeal or not.
That's another. This or buy do something.
Yes, sir.
So, for that, indeed for today's judgment. For the judgment pass now. What? Office.
In Jesus' name we pray. Divine Father, Lord Jesus, we thank you. We bless your holy name for this day, for this wonderful occasion to intercede for our country Nigeria. Everywhere to you, Lord, are all the rest from the beginning of the earth. Nigeria is nation broken by accident. After what we are passing through, the eternal plan of God is in it. The purpose of God is in it. The mission of God is in it. The vision of God is in it. The purpose of God is in it. Only God, Almighty, and Queen, for our leaders, whom you have raised up to lead and direct us.